Hi everyone, this is Dr. Tracey McCarthy, psychologist, attorney, and educator. Welcome to the community classroom. We are continuing on with our discussion on reparations. This is Reparations 102. This is part 2 and the final part of this particular series. What we're going to do here is we are going to clear up some legal language so you can get out your pens and papers and tablets. We're going to go through this pretty quickly, but efficiently. All right, so let's get started. So to get you thinking, to give you a prep of what we're going to cover the constructs of unjust enrichment, quasi-contract, constructive trust, equitable defenses, reparations classes, determining cutoffs, and research project information. Now, as you recall from the first video discussion, we talked about the construct of unjust enrichment. And so we're going to quickly go over that. Unjust enrichment is basically an equitable construct, and it basically says that no person should be permitted to profit at someone else's expense, and restitution in those cases require an exchange of reasonable value for any prior services or benefits or property that might have been received or retained. And so we're looking at this in terms of the construct of enslavement and unjust enrichment related to labor, perhaps in some instances the taking of land and things like that. And so there are three components, or what we call in law, three elements. And so you have the defendant received something or took something of value from someone else when compensation would have been reasonably expected, but they took the thing of value, whether it's the enslaved person's entire life, or whether it's the labor, or whether it's property rights. And then the second element would be that the defendant acknowledged, accepted, or retained, kept the benefit. They kept the resources. They kept the value that was received. And this value can be received either directly or indirectly. So indirectly, it would be like someone inherited this value, this benefit, or it was somehow transferred in some other way. And the third element is basically whatever took place is patently unfair, or it's shocking to the conscience. It's, just shocking. It's unconscionable. It would be unconscionable for the person who received this benefit for free. It would be unfair. It would be shocking to the conscience for them to keep the benefit, enjoy the benefit, retain the benefit without paying value for the benefit. And the next construct is what is known as quasi-contract. And quasi-contract basically says that restitution should be provided when someone receives services or benefits, even if they haven't requested them. And so you have basically this non-express contract. It's not a real contract. It's a contract that's created by law to prevent unfairness. And so even if the parties didn't have a contract, written or verbal, the courts can actually create a contract. And the second part would be that the person, the defendant, received some sort of benefit, and that the quasi-contract basically says that the defendant would need to reasonably pay reasonable restitution for the receipt of the services or the benefit. Let me give you an example. I don't know if you're familiar with anyone who's ever received a notice from the city for having their grass uncut. The grass is growing really wild. They receive notice after notice to cut the grass. They didn't cut the grass. What happens? The city comes in and the city cuts the grass for them. Now, after the city cuts the grass, what happens? The city sends them a bill saying you need to pay for the cutting of the grass. Another instance is, and this comes up, people think about this, people can actually imagine this one. I don't know if you've ever stopped at an intersection and someone with a bucket and water and a squeegee, they come up and they, motion that they want to wash the windows. And some people will actually allow them to wash their windows and then think that they should just drive off. And you might notice, if you've ever seen anyone do this, the person who has washed the windows is not going to be particularly pleased about this. Well, in fact, that person generally has a right to compensation. The person sat there, they allowed them to clean the windows. They knew that the person wasn't cleaning the windows for free. Most people would expect compensation when they work for someone. The same thing with slavery. The reason slavery existed is because people wanted someone to work for them for free. They wanted to be free not to work and have someone else do the work for them. And the work that was done was work that a person would be expecting compensation for. And so in that way, the slavery, the work that was done during slavery, could fall under this construct of quasi-contract, even though there is this theory that the individuals were enslaved and weren't actual human beings working and doing all of this work. The fact that their lives were actually stolen and basically considered stolen goods. If you recall the previous discussion about the receipt of stolen goods, then you have this same sort of dynamic going on. And so what you're talking about when it comes down to the quasi-contract level, you're talking about essentially a lifetime of free employment. And some people might argue, some people are very narcissistic and really have no respect for other people's rights. They might say things like, well, they received food, clothing, and shelter for their work. And a response to that is, that's the cost of doing business. That is not compensation for an entire lifetime of working free for someone else day in and day out. Quite frankly, it's the rare individual who would just show up at someone's company and say, they are coming there to work for free every day of their life without the expectation of any form of compensation for their time. And here you can get an idea of some of the types of work that the enslaved individuals did for the individuals who enslaved them. And so, as anyone can imagine, no one is going to volunteer to go out and work in a cotton field for the entirety of the person's life without any type of compensation. That is just an unreasonable expectation. It's unconscionable. Again, we're talking about some significant narcissism if someone actually thinks that. And there are individuals who are so narcissistic that they actually believe that they are entitled to the labor of others. They are entitled to the rights of others. They have no obligation to respect the rights of anyone else. And so for some people that actually does make sense, but it does not make sense to the common mind. Okay, so now when we take a little turn here, we're going to talk about constructive trust. And so let's quickly talk about what a trust is first, and just in really plain terms. It's basically you're holding property or assets for another person or for the benefit of another person. And that's it in really simple terms. It's a little bit more complex than that, but that's the simple way of understanding it. Okay, so let's look at this idea of a constructive trust. And basically, a constructive trust is imposed to benefit or compensate a person, a party who has been wrongfully deprived of the person's rights. And it comes from the person who is holding the rights or holding the property, that individual or that entity is holding something that they should not possess, because it technically, the rights or the property, the rights in the property, they belong to someone else. And you see this happen when there is a breach of duty of some sort. There has been an unjust enrichment, and where the person's property rights have been interfered with in some sort of way. So, of course, enslaving someone and taking all of their labor, that would be an interference with property rights. Taking someone's land without compensation, that would be interference with property rights. It would also be unjust enrichment. And remember, in terms of equity and fairness, no one should be permitted to profit at someone else's expense without compensating them in some sort of way. Now, in the situation with the Native Americans, the indigenous people who received compensation through treaties for giving up their land and moving out west, that's what all of that compensation was about. It was to compensate for the land, compensate for moving, being willing to move on to reservations and things like that. Now, there is some argument, if you actually ever look at any of these treaties, you will see that in some cases that even the treaties were unfair. And so there was still this unjust enrichment. And the dynamic with the tribes, those nations, is a trust dynamic where the United States holds things in trust for the Native American, indigenous American Indian tribes. Now, of course, this only applies to certain tribes, because there are a number of tribes who have never been compensated. There are a number of tribes who are not what's known as federally recognized, and some of those tribes tend to be disproportionately black or colored tribes, or what some refer to as copper colored tribes. Now, sometimes an example helps. So consider this. A person steals a car. That person sells the car that they stole, and then they take the proceeds from the sale of this stolen car and they put it in a bank account. Now, what the court can do in terms of this constructive trust idea is the court can trace the car theft proceeds to the bank account, and then the court can determine that the bank account is actually held in trust for the benefit of the victim of the car theft or the heirs of the car theft victim. And so in a way, it's like the person stole the car, they sold the car, and then they took the money and put it in a bank account. And so the way the court looks at that is they actually created a trust account for the victim, and they held it in a bank account, and whatever profit comes from that, if there's any interest, then theoretically that would belong to the victim or the heirs of the victim. Okay, let's look at some other examples, and we're going to go back to that issue of receipt of stolen goods and this idea of money laundering, which in many cases might have been what happened with a lot of the slave trade assets. And so basically what you're looking at is transforming the proceeds of a crime, the slave trade, into legitimate money, interest, or other assets. We can use Tony Montana as an example. It would be something like, in modern times, Tony Montana buys a shopping mall from drug sales and then lives off of the proceeds of the shopping mall. Or in the alternative, Tony Montana purchases homes, cars, and boats for family members from the proceeds of the drug sales. And so they are benefiting from the drug sales, but it's been funneled off into a legitimate asset. And then if we look back in less than modern times. We look at Queen Charlotte and King Adandazan, who their families were involved in the slave trade. And so instead of shopping malls, these individuals could have built castles, purchased land, and then willed the proceeds from the slave trade to their descendants, who invested in real estate, car manufacturing, stocks, or any other legitimate business venture that you might see today. And so if there is an unjust enrichment dynamic going on, the courts could conceivably hold that these assets are actually held in trust for the individuals who were originally entitled to the assets and the benefit of the assets. Now, one of the things that you need to understand about equity is that there are defenses to equity. One defense would be this idea of unclean hands. And it means basically requesting assistance in terms of fairness, but the person has been involved in the wrongdoing. So it'd be like the descendants of slave traders actually asking for reparations when in fact they are direct descendants of slave traders and have benefited financially or in other ways from that slave trade. Another thing to consider is this idea of first in time. And sometimes what might happen is there may be a remedy available, but someone else may come to claim that remedy first. You can think of the biblical story of Jacob and Esau. And once someone has taken the birthright, if someone else comes to get the birthright at a later time, the birthright no longer exists. So the inheritance no longer exists. Of course, you could argue that between Jacob and Esau, perhaps there was an unjust enrichment, or maybe Jacob was holding things in trust for Esau. You know, of course, that's all debatable. All right. And so the final thing, which is very, very important in this issue, is this idea of laches. And laches is basically sleeping on rights. And so these equitable rights don't just go on for forever. You know, someone can't come 1,000 years later and start talking about reparations. The time is now ripe, given that the United Nations has made a determination that reparations are due, and also Jamaica is making a claim for reparations at this time. And so this is a ripe time in terms of history, and you have gotten past the Civil Rights Acts, and so you've gotten past Jim Crow, and so now that option is available. I think in many instances, the reason why the issue of reparations has not had much forward movement is that there have been lots of distractions and derailments. And oftentimes there's a Trojan horse dynamic going on. And so you have individuals who theoretically should have been advancing things quite a while ago. And not only did they not advance it, but created all sorts of distractions and derailments. And actually, sometimes when you hear some of the discussions on YouTube, some of these quote unquote movements, they seem like distractions and derailments. The distractions and derailments can also, of course, exist outside of YouTube or social media. And so all of that is said to say that waiting another 400 years is not going to be a helpful idea. And for those who are not aware, this decade that we're in right now has been identified as the decade of the African descendants. And so now would be a good time to start to get some sort of forward movement on that issue. Okay, so we're going to start to wrap this up, and we're going to discuss this issue of a reparations class. And there again, as mentioned in the previous video, there needs to be a boundary. So there needs to be a boundary created around the individuals who would theoretically be entitled to some form of restorative justice. And so the idea that might be helpful in terms of thinking about it might be this idea of creating a role similar to the Baker role, or the, I believe it's pronounced Guillaume Miller role, or the Dawes roles. And these are the roles that were created in relation to indigenous, Native American, Indian individuals. And so the suggestion, and this is just a suggestion in terms of creating that boundary, because you do have to create a boundary. You have to create a boundary so that certain individuals are included and certain individuals are excluded from this boundary. And so you want to create something like a role, and it would be something almost like a census where people would apply to be a member of the class. And this could be a part of the research project, is that the students could basically create these roles, do sort of a campaign to create these roles. And what they could do is could basically focus on, this is probably a pretty good cutoff, would be focusing on all individuals in the United States who possess government issued proof that at least one parent or ancestor was born prior to May 1st of 1968. And this would help with creating that line of demarcation, that cutoff. And that time frame is an appropriate time frame because that is really the ending, that sealing of Jim Crow. And so you would have from slavery to the technical legal ending of Jim Crow. Now I realize that there are some other things that go on and have been going on, but in terms of the law, this is a good cutoff. And so you could have the classification be individuals or individuals who have ancestors, a parent or an ancestor who was born prior to May 1st, 1968. This is classified based upon live birth documentation, and the individual who has this birth prior to 1968, May 1st, there would need to be a classification on the documents that the individual was born, and they were identified as Black, African American, Negro, Colored, Black Creole, Black Indian, Black Indigenous, Black Native American, or having any tribal affiliation, tribal membership in any Black Indian tribal group. Now, if students decide to take on this type of project, the role could include applications. And so the applications would include things like the proposed member's name, their full name, the date and place of birth, the names and ages of siblings, their sisters and brothers, the place and date of birth and death of parents and grandparents, the person's current residence, any spouses and any children, and the names of any extended family members. And this would also, of course, help with verification. And I also want to remind that this would need to be done irrespective of a person's skin color or any other physical appearance. The issue is about being a descendant versus belonging to any ethnic group or any cultural group of any sort or any particular race. And I'm going to use Diana Ross as an example because she has not only biracial children, but then she has grandchildren who may or may not be perceived as having a Black or an American Negro or a colored grandmother. And so those still are her descendants, however. And finally, some ideas about conducting the student research. So if students decide to take on that task, what the recommendation would be that the researchers would be restricted to the descendants of Black Americans, American colored persons, American Negroes born in the United States prior to that 1968 cutoff. And so these would be individuals who are interested parties actually doing the research versus external parties doing the research. Now, one individual who identified himself as a student, the person was K Hayes 1098, I think was the YouTube name. They mentioned that this issue came up at an HBCU meeting, and they were asking some questions about the prudence of students taking this on and HBCUs taking this on. I think the focus needs to be on, instead of any particular institution taking anything on, needs to focus on students who have certain backgrounds. And so those backgrounds would be, or those disciplines would be, history, political science, religious studies, anthropology, art, geography, African and Black studies, European studies, indigenous studies, law, biology, human development, and ancient studies such as focusing on Assyria, English, and human rights. And so those are some of those areas that would be beneficial in terms of doing the research to get the information. The other majors or areas of study would be math, statistics, computer science, and video and audio production. And finally, another collective of students that would be necessary and helpful would be those who have backgrounds in foreign languages and literature. And the specific foreign languages that you would need would be Spanish and Portuguese, French, Latin, Danish, Arabic, Dutch, Yoruba, and some of the other African languages that would be spoken perhaps by the ACON, and those who are familiar with older forms of English. Now, I realize that a lot of people do things like GoFundMe and things like that. I don't think that that's a good idea in terms of funding. The funding, if someone wants to support this type of project, should probably go directly to official student groups on actual campuses. If individuals want to contribute, community members want to contribute, community groups, they might want to consider things like gifts in kind, such as copy paper, flash drives, pens and folders, and record keeping materials, statistical software, books. People might need history books. Funding for local travel, meaning within the area, or admission to museums and research centers. There could also be funding for independent research or study courses. But you want to be careful about just giving blanket funding to any entity to do this type of research project. And any research project is probably best done by collaboration versus having someone who is sort of individually overseeing the entire process for everyone. Sort of that centralized top-down dynamic. That's probably not the best way to conduct these types of research projects. And they probably also should not be limited to students at HBCUs, or students who are only graduate students or undergraduate students or law students. There should be some sort of diversity. And quite frankly, if HBCUs were planning to do this type of research, they've had quite a while to do it. And if they haven't done it by now, they're probably not going to do it. And so the projects should not be limited to HBCUs, and HBCUs are probably not the best representatives for the projects at this time. And also that would include the Congressional Black Caucus, because if the Congressional Black Caucus was going to take it up, they would have taken it up by now. Now, if students want to, at the end of gathering all of their data, if they want to consult with the Congressional Black Caucus and see if there's something that the Congressional Black Caucus can do to assist, then that's probably fine. You have to be careful about having other people represent your interests collectively, because there have been some instances throughout history, when you look at Native Americans and Indians, when you look at what happened with some of those treaties, some of those people, their rights were signed away by people who were acting as a proxy, who were speaking on their behalf. Basically, in some instances, it looked like they were representing people and they really weren't necessarily members of those groups. Or they were really marginal members of those groups. So you want to be really careful about having other people speak for you or do things on your behalf. Hence, the limiting the research projects to the descendants of Black Americans, American colored persons, American Negroes, copper-colored indigenous people, having it limited to those individuals who have ancestry prior to 1968. Also, one other thing is there should probably be diversity in terms of socioeconomic status, in terms of the students who are doing the research. So you don't want a limited vantage point in terms of how the research is done and how the information is collected. And sometimes individuals in certain SES groups, they may see the world through a particular lens and they may miss certain things that someone from another SES might catch. And the final thing, as we wrap this up, as people are considering doing projects or they're considering doing some research on these issues related to reparations, one of the things I want to encourage people to do is to learn how to accept the research of other people and accept the cognitive challenges that go along with looking at the world through different lenses. Sometimes one of the things I've noticed on YouTube is that individuals will present some research, they'll present some sort of scholarship, and people will go from simply appreciating the scholarship and the sharing of information and insights to actually deifying human beings, and they sometimes develop a cult-like following. And so when that happens, then sometimes people are unwilling to entertain other perspectives from other people who are doing other scholarship. And so they get into this dynamic of confirmation bias where they only see the world through whatever lens it is that they want to see the world through. And then when they get evidence that negates or refutes something that they believe, they dismiss it or ignore it. And when you do that, when you can't hear someone else's perspective, you're going to lose the opportunity to learn, and you might actually miss an avenue of research that you might need to pursue. And so you don't want to just tune out voices that are not saying what you want to believe based upon the research that you already have. There are instances where someone learns something totally new and they go down a totally different path based upon some conflicting data. And so what you're looking for, instead of just confirmation bias, getting someone to confirm or co-sign on what you already believe, what you're looking for is validity and reliability. You're looking to see if one person found it, do you find it when you go looking for it? Do you find any evidence of what they are talking about? And if you do find evidence of what they are talking about, what are the implications of that? When you look at things, you look to see not just that you found a fact, but does this fact actually attest to what it's supposed to attest to, or whatever it is you believe it's supposed to attest to? And if someone else looks at that same fact, will someone else conceivably see it through that same lens? Now, of course, may be instances where no one is going to see it through that same lens, and that's fine. They don't have to. Sometimes a fact may not be evident to other people until they're ready to see the fact, they're ready to receive it. Now, a lot of people get sidetracked on YouTube and in social media, and they get sidetracked and they're off on all sorts of different things and losing focus on whatever it is that they are supposed to be doing. They don't have a single point focus. And in order to do the research, do the projects, in order to even get to the point where you can start to present things related to reparations, you have to have that single point focus. Cannot be constantly distracted by every wind that blows and every theory that someone throws out there, because again, that issue of staying in one's lane and censorship comes up. There are lots of people on YouTube and just out in the world, but more on YouTube, that are insistent that people believe the way that they believe, that they see the world the way that they see the world, and that they identify the way that they identify. And so there are actual individuals who are derailing research of other individuals because they want those individuals to buy into whatever theory it is they have about identity and about heritage. And they are in many ways insistent that everyone be from the exact same background. And that's just absolutely unreasonable and ridiculous. Just because one person has one heritage does not mean that the person next to them has the same heritage. And so people need to be free to pursue their own interest and their own paths in terms of their heritage. Each person has a different family story, and so each person has a different genetic pathway. And so for those who are planning to do some research toward this end, if one of the ways you can think about it is, again, that tribe and vibe dynamic. If you feel wholeheartedly that your heart is in Africa, then perhaps that's because that's where your roots are. If someone else, however, feels that their roots are in Mississippi, for instance, or their roots are in Alabama, for instance, and that's where they trace it back to, then learn to allow other people to have their own story and their own heritage. Your story is not everyone else's story. And for those who start to do this research, you will find that people in Nova Scotia, for instance, will have yet another story. And so allow all of those stories to be made manifest so that you can get to greater facts and a greater sense of truth. Okay, let's wrap this up. Remember, knowledge is power. Take care and see you soon.